Lumo niyan. Pati pagkain, pinakialaman. For bar purposes. But after the bar, kahit araw-araw, chichirya. Okay. Peanuts. Peanut brittle. So, hiningal po kayo. Grabe. Fifth floor ba to? Grapale. Parang hindi natatapos, no? Parang, bakit another floor? Fifth floor. Okay. So, please take note of the information required to be disclosed under the Truth in Lending Act. So, they are found in Section 4. Section 4 of your law. Okay. The amount to be credited as down payment or trade-in, the cash price or delivered price of the property or services to be acquired, the amount to be credited as down payment or trade-in, because normally, di ba, you borrow 1 million, but the total amount that you will be getting is only, let's say, 900,000, no? Why? Because the first 100,000 was already applied as initial or first installment, okay, if the loan is to be amortized, no? So that has to be disclosed also to the borrower. Charges which are to be paid by the borrower in connection with the transaction, but not incident to the extension of credit. The amount to be finance charge, which should be expressed in terms of pesos and centavos, and percentage of the finance charge. By finance charge, Section 3, Paragraph 3 of the Truth in Lending Act contemplates interest, fees, service charges, discounts, and other charges which are incident to the extension of credit, as the board may, by regulation, we are referring here to the monetary board, the board may, by regulation, prescribe. Now, please take note of Section 6 of the Truth in Lending Act, no? Basic question here is, what are the possible remedies in case of what? Violation. Remedies available to the debtor in case the creditor failed to comply with the requirements of the Truth in Lending Act, specifically disclosure requirement contained in Section 4 thereof. Okay. Well, there are two possible scenarios, no possible remedies. Civil, one is civil, the other one is criminal, no? Civil liability is found in Section 6, no? Iho, talagang bilib ako sa'yo, yung knapsack mo, dala-dala mo pababa, tas dala mo pa rin pabalik, no? Kasabay kitang bumaba, hindi mo ba napansin? Talagang, pero okay yan, exercise, di ba? Exercise. With matching knapsack, kasama ang mga libro. Tapos pagbalik, akyat na naman, di ba? Parang ako, dala-dala ko yung gamit ko, di ba? Eh, may laman pang bakos yung bag ko, di ba? 10 bakos ang laman. Parang pareho lang tayo, mas maliit lang yung bag ko. Pero pareho lang. That's why, naiintindihan ko kung paano ang naranasan mo nung pagbaba at pag-akyat dito sa 5th floor. Okay. No. So, yung civil po is found in Section 6, no? The creditor concerned, napakalaking amount, no? Well, liability is in the amount of, napakalaking amount, 100 pesos, or in an amount equal to twice the finance charge required by the creditor in connection with the transaction, with the qualification whichever is greater, but with a further qualification that in no case shall liability exceed 2,000 pesos on any credit transaction. The period to recover the amount on the part of the debtor concerned, no, affected debtor is only within 1 year from the date of the occurrence of the violation. Magkakaso ka pa ng ganito, magkano lang naman ang masisingil mo. Now, please bear in mind, class, that this liability may be pursued independently of or separately from the criminal offense, as I have earlier adverted to in Section 6, Paragraph C thereof, no? So, yung criminal liability po, the provision on criminal liability is found in Section 6, Paragraph 3. Any person who willfully violates any provision of the Truth in Lending Act, ito ang nakakatakot, shall be fined by not less than 1,000 pesos nor more than 5,000 pesos or imprisonment of not less than 6 months, no? Nor more than 1 year or both. So this is the provision that you should seriously look into if you're the creditor concerned. Okay? Ang masaklap po dito, syempre sisingit na naman yung immunity natin, di ba? 6 paragraph D explicitly states that the punishment or penalty provided in this act, okay, shall not apply to the Philippine government or any agency or any political subdivision thereof. So that's the immunity clause insofar as the state and its instrumentalities are concerned. Now, please take note that I emphasized a while ago, no, before we had our break, that the obligation to disclose is expected to be done prior to and not after the consummation of the loan transaction. The bank cannot comply, or the bank cannot escape compliance by the mere fact that the borrower was subsequently furnished with the disclosure statement requirement of Section 4, no? Subsequent disclosure will not cure the deficiency. UCPB versus Spouses Beluso, August 17, 2007 case. The subsequent disclosure will not excuse the creditor concerned from liability. Okay, yan. The reason is, as I said, the reason is to protect users or borrowers, to be able to enable them to ascertain the interest that they're going to pay, the amount of interest that they're going to pay, avoidance of so-called hidden charges and unwarranted deductions, and so they may be able to fully appreciate the cost of their borrowing, and they're able to evaluate the options that are available to them. And so, in the giving of consent to the loan transaction, we could be assured that here the debtor was able to give full consent, ba? Full consent to the loan accommodation. Now, basic question here is, ano pong effect dun sa loan, assuming there's violation of, kasi nasagot na natin, what are the possible remedies that you can take against the erring creditor, no? So as I said, pwedeng civil, pwedeng criminal, and recourse could be taken separately, independently of each other. But how about its effect on the loan itself, no? DBP versus Arcilla is the answer. GR number 161397. Actually, these are consolidated cases involving another case also where the petitioner is, apparently both parties filed a petition before the Supreme Court, and both petitions arising from the same case. Okay? Ang nangyari po dito, empleyado si Attorney Arcilla, hindi po siya yung professor, no? Felipe Arcilla was employed by the Development Bank of the Philippines, and he was assigned as to the legal department, and thereafter he decided to avail of a loan under the company's under the bank's individual housing project. Mr. Arcilla executed a deed of conditional sale The parties, DBP and Arcilia, executed a deed of conditional sale over the property, okay, as well as the house to be built thereon for the price of 160,000 pesos. Kasi nung unang panahon pa to, yung 160,000 pesos, ngayon po 160 million na yan, di ba? Okay. Hiniram po yan ni Arcilia for yung amount po na yan ay hiniram ni Arcilia for the purchase of the lot as well as construction of the his residential house. Now, upon payment of the loan, ang obligation ni DPP is to transfer the usual, no, title to Mr. Arcilia. Well, of course, it's upon payment of the loan. All right? It was agreed that if Mr. Arcilia will avail of optional retirement, he could elect to continue paying the loan, or he could convert yung kanyang real estate loan with the prevailing interest. Well, anyway, this info, the date, the material, these details are no longer material. Anyway, so nagkaroon po ng promissory note, no? Pinapirma siya ng promissory note aside from the deed of sale, conditional sale that I mentioned to you a while ago. Merong service charge and interest provision in the promissory note and other things, other items that he is required to pay, no? Nonetheless, nung nagkakasingilan na, at sinisingil siya specifically ng finance charges, umangal itong si Attorney Arcilia because he was claiming, I was not properly advised of these other charges, no? So to him, these are hidden charges. I was not properly apprised of these additional charges, and therefore I am questioning the bank's requirement for me to pay these charges. He specifically, nung nagkaroon na ng action, no, he specifically claimed that DBP failed to furnish him with the disclosure statement required by Republic Act 3765, which is the Truth in Lending Act, and Central Bank Circular 158, no? Kasi meron pong circular na ipinasa si Central Bank in relation to the Truth in Lending Act, specifically prescribing, among other things, the form to be followed in making the disclosure statement under the Truth in Lending Act. And as far as Mr. Arcilia is concerned, there was no compliance on the part of DBP with regard to the disclosure requirement of the Truth in Lending Act and also Central Bank 158 before the sale, execution of the deed of sale, as well as the conversion of his loan into a regular housing loan. Nonetheless, DBP continued deducting the account from his salary as early as 19, yung amount representing the additional charges, continued deducting the same from his salary as early as 1984. Well, for DBP's part, okay, ang claim po ni DBP is that it has substantially complied with the requirements of the Truth in Lending Act and the circular in question because the details required under the Truth in Lending Act were specifically disclosed in the promissory notes, deed of conditional sale, and the required notices sent to Mr. Arcilia. In any event, its failure to comply strictly with 3765, kasi may separate na form for the disclosure. Ang ginawa ng bangko apparently is to incorporate, no, the matters required to be disclosed under the Truth in Lending Act doon sa documents that I mentioned, promissory note, deed of sale, etc. Okay, in any event, contention of DBP was that, assuming that I have failed to satisfy the requirements of the Truth in Lending Act and the circular of the BSP on the matter, such omission did not affect the validity as well as enforceability of the transaction. Okay? So this is the critical question the Supreme Court is now being called upon to decide. Ang katwiran po ni Mr. Arcilia, under the law and the circular adverted to, the mandate is for the creditor bank to furnish him with the required information in such form prescribed by the central bank before the consummation of the loan transaction. The disclosure of the details in the PN, promissory note, and deed of conditional sale do not constitute, according to him, substantial compliance with the law and the circular issued by the BSP. He further argued that the failure to comply with the requirement of the Truth in Lending Act forecloses its right to rescind the transaction between them, forecloses DBP's right to demand compliance, okay, of his obligation arising from the transaction. And the bank doesn't have the authority to deduct the monthly amortizations from his salary without first complying with the mandate of the Truth in Lending Act, whose position class was sustained by the Supreme Court. The Supreme Court here sustained the position taken by DBP. Subok na matatag, subok na matibay. According to the Supreme Court, ano ba yung bangko na yun? Bangko Sentral ng... Hindi, merong ganun eh. Bangko Filipino. Subok na matatag, subok na matibay. Anyway, the petition of Arcilia has no merit according to the Supreme Court. And so it laid down the requirements of the Truth in Lending Act. The circular adverted to states that the contract covering the credit transaction or any other document to be acknowledged by the debtor should indicate the above items of information. The contract or documents are specifically indicate the additional charges, if any, which shall be collected in case certain stipulations in the contract are not met by the debtor. Okay? If the borrower, according to the Supreme Court, is not duly informed of the data required by law, required by the Truth in Lending Act prior to the consummation of the availment or drawdown, the lender will have no right to collect the finance charges or increases thereof, even if stipulated in the promissory note. However, kasi ang contention ni Arcilia, di ba? No more recourse on the part of DBP to collect yung amortization mismo doon sa loan, no? Ang sabi po ng Supreme Court, no, in effect, parang ang position niya is ineffectual yung ating kontrata kasi hindi ka nakapag-disclose pursuant to the Truth in Lending Act. But that was not taken seriously by the Supreme Court. The Court said that the bank on the assumption, ito assumption pa lang, na hindi nga po natupad ni DBP yung disclosure requirement sa Truth in Lending Act, ang effect lang daw po niyan is for DBP to be foreclosed from collecting finance charges as well as increases thereof, though the same may have been stipulated in the promissory note. Ang bilis ko ba? Mabilis ba ako, kuya? Hindi, okay lang. Nakakahabol ka. Kasi nagno-notes ka, di ba? Kasi pag binagalan ko, aantukin ako eh. Kaya kailangan kong uminom na naman ito. Nakainom na ako ng isa, hindi naman pwede, di ba? Hindi ito dapat araw-araw pag kailangan lang, as needed. Kasi energy drink yan, di ba? May sugar-free po nito. Sa 7-Eleven meron yata. Okay, so ang effect lang daw po niyan, pag kailangan lang, as needed lang. Pag talagang wala nang pumapasok, feeling nyo wala nang pumapasok, pero marami pa rin kayong alam, di ba? So sabi po ng Supreme Court, the failure, okay, assuming there was such failure, shall not affect the validity or enforceability of the loan transaction. Okay? In the present case, it is true that DBP failed to disclose the required information in the disclosure statement form. I told you, may form na prescribe dun sa circular. But instead, it did so in the loan transaction documents between it and Arcilia. There's no evidence, however, on record that DBP sought to collect or collected any interest, penalty, or other charges from Arcilia other than those disclosed in the deeds or documents. Okay? So sabi ng court, mukhang since na-incorporate naman daw dun sa promissory notes, etc., no? We believe that there is already a substantial compliance with the disclosure requirement of the Truth in Lending Act. Aside from this, no, kasi it's more of information, no? What's the purpose? You being informed, you being notified, you being made aware of the cost of your borrowing. Has that purpose been served in the instant recourse? The court class was convinced, very much convinced, in this particular case, considering among other things, yung profession. Kaya minsan nakakasama pag abogado ka, di ba? Yung profession daw po, ha? Anong profession? Ano ang educational background nitong si Mr. Arcilla? Isa kang abogado, di ba? Abogado, di ba sabi ko, Attorney Felipe Arcilla. He was assigned where? Legal Department of the DBP, di ba? Sabi ng Supreme Court, a lawyer, citing another case, of course, but with similar factual antecedents, no? A lawyer would not be so gullible or negligent as to sign documents without knowing fully well the legal implications and consequences of his actions. And that, okay, he is presumed knowledgeable with the matters relating to the business of DBP, kasi employed din siya sa DBP, di ba? And fully cognizant of the terms of the loan he applied for, including the charges that he had to pay. It would have been different, according to the Supreme Court, if the borrower was, say, an ordinary, the court is actually quoting the findings of the Court of Appeals. So it's practically referring to the same case, no? It might have been different, according to the Supreme Court, if the borrower here was, say, an ordinary employee who is so eager to buy his first house and is easily enticed into accepting onerous terms so long as the same is payable via installments. In such a case, the court would be disposed to be stricter, di ba? Sabi ko sa inyo di ba? So, ngayon pa lang, i-enjoy nyo na muna ang buhay nyo habang wala pang period sa inyong ATTY. Kasi minsan, nakakasama sa kaso. Okay? Pag ikaw na yung involved, no? The court would have been more strict. The court would be disposed to be stricter, no? In the application of the requirements of the Truth in Lending Act, insisting that the borrower be fully informed of what he is entering into. However, in the case at bar, considering Mr. Arcilla's education and training, the court must hold, in the light of the evidence at hand, that he was properly, duly informed of the necessary charges, okay, and their corresponding implications and effects. Accordingly, okay, we do not find the position taken by Mr. Arcilla meritorious. You get it, okay? So please take note of the court's decision. It's one of the leading cases so far, as far as kasi kukonti lang po ang kaso sa Truth in Lending Act. So medyo maganda itong case na ito. Baka ang tanong ni examiner would failure to comply with the Truth in Lending Act affect the validity of the loan transaction? I think that the message of the Supreme Court here is very clear, no? It's valid, remains enforceable. Nonetheless, the creditor, assuming there was such failure, no, will be forbidden from collecting payment of finance charges as well as any increases thereof, though the same may have been stipulated in the loan document. Okay? All right. Okay, let's now move on to banks in distress. But later we will still discuss certain restrictions with regard to, or requirements with regard to ownership of banking corporations. Let's discuss first the more important item, which is about banks suffering financial distress. No? Okay. You know for a fact that banks are closely regulated by the Monetary Board. Close supervision is expected from the Monetary Board. So regular inspection of record, examination of record, FS, financial statements, and other documents of the bank should be expected from the yung audit, no? I was telling you a while ago, because I serve as legal counsel of our Savings and Loan Association. It's a non-bank corporation, but it performs some banking functions like savings, nag-accept po yan ng savings at saka time deposit. And still, it's under the supervision of the Monetary Board, the BSP. Merong naka-designate na supervising authority or agency, department, na in charge of monitoring the activities of our Savings and Loan Association. And I must tell you, every 2 years kasi nag-audit sila. Yung audit po ng BSP is a serious matter, no? Hindi yan yung audit na nakikipagkapehan lang yung mga taga-BSP. Bababaran ka nila talaga. They will stay there and look into your records for almost a month. Nandun po yung mga taga-BSP. So talagang very thorough, very detailed ang audit ang audit activity being conducted by, audit exercise being conducted by the BSP. So it's a serious matter, and of course, yung mga recommendations that would be coming from the auditors should be taken seriously. Otherwise, sanctions may be imposed by the BSP. So kung yun nga, yung asosasyon na yun is not even a bank, no? How much more when it comes to a banking corporation? All right. So that in the exercise of monitoring, okay, so it's not as simple as monitoring, because if there is something wrong, the bank is no longer operating in a safe and sound manner, no? Why? Because it is having a serious problem with regard to its finances, no? Certain remedies may be taken by the Monetary Board to address the situation. One of which is to extend loans and advances to the bank, even without requiring the bank to present or to provide a collateral therefore, no? That's under the new Central Bank Act, no? Okay. The amount, the emergency loan or advance says to be extended, however, should not exceed 50% of its total deposit with the central bank. And the loan is to be released in 2 tranches, okay? 2 installments, all right? However, baka hindi ganyan ang sitwasyon. Yan, emergency loan lang. So that is, the financial situation is not that serious, okay? If the scenario is one where the bank is not that liquid to enable it to attend to its day-to-day activities, no? Problem niya is liquidity. Anong ibig sabihin ng liquidity? Okay? Kailangan maging tubig siya. Agua. Ano ba yung palabas? Ano yun? May pinapanood si Ayola eh. Kasi nagsuswimming siya eh, para daw maging, agua bendita yun, okay? Kailang maging ganun siya, agwa? Of course not, okay? It's more on what? Having enough cash to attend to your day-to-day operations. Di ba, madam? Why are you alone? Inaaway ka ba nung dalawa? Pag kinapi-api ka nila, isumbong mo sa akin at ako mag-aabogado sa kanila. Hindi, sa iyo. Okay. Okay lang ba sila, mga friend? Mga estudyante ko yung dalawang yan. Mababait naman po sila pagkaharap ako. Okay? So, are you okay there? Yeah. Kinukumusta lang kita. Okay. So ang sitwasyon lang po dito, scenario here is liquidity. It's just liquidity. The corporation, the bank does not have enough or sufficient cash to enable it to attend to its day-to-day operational activities. The proper recourse, this is, of course, the result of the examination conducted by the BSP, no? Through the appropriate supervising department. So it's in a state of inability or unwillingness to maintain a condition of liquidity, which condition is necessary to protect the interests of whom? Depositors and creditors of the bank, no? The Monetary Board, in the exercise of the state's police power, di ba? Through the Monetary Board, pwede po siyang mag-appoint ng tinatawag na conservator. So, madali lang naman po sigurong tandaan yung term conservator, as in conservatory of music. Di ba? Pianissimo, fortissimo. Okay? May appoint a conservator with such powers as the Monetary Board shall consider necessary under the circumstances. the period for conservatorship is only 1 year. Okay? Now, the requirement class for the conservator is, well, basically general requirements such as, or qualifications such as competence, no? And knowledge, or he should be knowledgeable on bank operations and management. So, ang conservator, hindi siya si PDIC, ha? Okay? Ang PDIC, papasok yan sa receivership, no? Pero for purposes of conservatorship, it's within the discretion of the monetary board who it deems qualified or fit for the task of conservatorship, no? The BSP could opt to designate a person who is connected with the BSP to act as a conservator class, no? Better nga yun kasi at least mas kilala na, may reputasyon na, okay? Alam ng BSP, ng monetary board na ito yung kanyang qualifications kasi he is one connected with the BSP itself, no? However, class, the limitation is that if such person will be appointed or designated by the monetary board to act as conservator, hindi po muna siya susweldo. Kasi susweldo naman siya doon sa bangko, no? As such conservator. But in the meanwhile, he would not be getting the usual salary that he's getting from the BSP, kung employed siya ng BSP. Okay? I think that's reasonable. Otherwise, dala-dalawang employer mo. Nagtatrabaho ka doon sa isa, hindi ka nagtatrabaho doon sa isa, yet pareho kang sumisweldo. That's the policy here. Okay? Well, the basic powers class, as also provided in most of the materials that you have, no, is to take charge of the assets, liabilities, and management, to take charge of the assets and liabilities of the bank, and effectively manage the same, no? It has the power to reorganize the management of the subject bank. It has the authority to collect all the monies and debts due the said bank, and the catch-all provision is, of course, exercise of such other powers as may be necessary to effectively carry out conservator of the bank. Basically, conservatorship is preservation of the assets, but the main objective of the conservator here is make the bank liquid. Make the bank liquid. Translation of assets into cash. So that when its debts mature, no? Hindi lang yung araw-araw, no? When its obligations mature, the bank would be able to satisfy all of these liabilities. So hindi lang po, kasing araw-araw, di ba? May nagwi-withdraw, that's payment of a debt, di ba? So that the bank should be able to handle all of this efficiently. And that could only happen if the bank has sufficient cash on hand to attend to its day-to-day claims, okay? Adverted to by depositors and other creditors of the bank. All right? Now, please take note, class, that under the law, as I said, the period is only for 1 year, no? Possible that the conservatorship is successful so that pwede siyang ma-terminate actually before the 1 year period if it will only take 6 months for the conservator to effect liquidity of the bank, then we could terminate it as early as the 6-month period, no? But if not, no, the scenario calls for a stronger recourse coming from the BSP. Matatapos po yung 1 taon, pero mauuwi yan perhaps sa tinatawag na receivership. Okay? So this time, or worst is liquidation. Pwedeng mag-jump ka into liquidation depending upon the circumstances. But I'd just like to point out at this point, no? I'd like to point out at this point. I'd like to stress at this point, di ba? Kasi puro point na, di ba? Baka pointed ang mga sapatos. Bakit pareho ang sapatos nyo? Pareho kulay, no? Ang galing, ha? Magkapatid na kayo. Okay. Galit na si Shock. Yan. Pati ba naman sapatos ko pinapansin? Hanggang dito ba naman sinusundan ako ditong mamsara ko? Okay. Class, conservatorship is not a condition sine qua non for receivership purposes, no? Depending upon the result of, or the findings of the BSP, pwede na pong matuloy kaagad sa receivership. conservatorship is not a condition sine qua non to receivership. Okay? There is no such requirement that before putting a bank under receivership, it should undergo first conservatorship. Okay? Nasa assessment po yan ng monetary board whether to put the bank already under receivership. Or even, the worst case is putting it under liquidation. Now, as mentioned a while ago, class, it is the PDIC, the Philippine Deposit Insurance Corporation, which will be appointed as receiver of the bank, no? No other, but the PDIC shall be appointed as receiver of the bank. But of course, there are reasons which would justify, okay, order of receivership. One is the bank findings of the BSP reveal that the bank is unable to pay its liabilities as they become due in the ordinary course of business. The bank has insufficient realizable assets as may be determined by the Bangko Sentral to meet its liabilities. Ibig pong sabihin, sa conservatorship kasi, the condition is the bank still has enough assets. Okay? But hindi lang siya liquid. In fact, ang assets niya, no, yung kanyang total assets, okay, will exceed the total liabilities. It's just that kulang nga siya sa cash. Yun po ang scenario. Pero sa receivership class, it's the reverse, no? The other way around. More debts than assets. Okay? The bank does not have sufficient assets, realizable assets, to meet its liabilities. If the bank will continue doing business, more losses will be incurred. Okay? More losses or probable losses will be suffered by those who have stake in it, no? Or that the bank has deliberately violated a cease and desist order that had already become final, which involved acts or transactions amounting to fraud or dissipation of the assets of the bank. Okay. Now, just like the conservator class, please note that we expect the receiver, the PDIC, acting as statutory receiver, to effectively manage the assets, properties, as well as liabilities of the bank and administer the same for the equal benefit of those who have stake in the bank. The receiver shall have the powers given to a receiver as contemplated under the rules of court. Okay? It could actually make placements also because ang point nga is we want the company to become financially viable again. The PDIC can likewise bring suits to enforce liabilities to the bank, no? It has that authority to bring under its charter, PDIC charter, no? It can bring suits to enforce liabilities to the bank, and ito ang nakakatakot, on the part of the officers and employees of the bank, it can go to the extent of what? Suspending, as well as terminating, okay? Employment of officers and employees of the bank. It can also, it's within the charter of the PDIC, borrow on behalf of the bank, if necessary, for the purpose of what? Preserving the assets, and of course, has the further authority to reduce interest on deposits if found to be exorbitant. Okay? Now, bear in mind, you are familiar with this, I'm sure. Okay? That the closure or the closure of the bank or putting it under receivership is actually an act that can be taken by the BSP ex parte without the necessity of prior notice and hearing. Okay? This exercise is embodied in the rule we refer to as close now, here later scheme. Close now, here later scheme. Basic rule is that no prior hearing is necessary in appointing a receiver and in effecting the closure of the bank. It is enough, however, that subsequent judicial review is available. Okay? It's due to practical considerations. You know how depositors react, di ba? You know how depositors react. Baka rinig lang po yan ng, uy, mukhang ba may balak na mababankrupt, di ba? Magkakagulo na yan sa bangko. Magtatakbuhan na lahat yan sa bangko, di ba? Bank runs, his panic and his hysteria among depositors will be the order of the day if prior notice and hearing will be made conditions precedent to the closure of the bank. Okay? In the case class of Central Bank versus Court of Appeals, the Supreme Court emphasized the rationale behind the close now, here later scheme. It's all because of the nature of transactions banks handle. The government has the responsibility to see to it that the financial interests of those who deal with banks are protected. Because otherwise, public faith in our banking system will deteriorate. The Supreme Court explained that it cannot subscribe to a situation where procedural due process has to take precedence over the more substantive interests and concerns of the depositors, stockholders, and other stakeholders of the bank. Okay? Nonetheless, as mentioned a while ago, class, subsequent judicial review is an available remedy. I'll discuss that in a moment. Okay? Now, just to let you know of the other consequences of receivership, no? Para po yung dun sa corporate rehab natin, no? Although the difference is that you do it via the monetary board. So hindi ka pumupunta sa RTC for receivership purposes, di ba? And ang difference kasi sa corporate rehab, di ba? That was discussed with you already, di ba? Sa corporate rehabilitation, wag kayong kumukunot ang noo. Sa rehabilitation, ini-initiate yan via a petition. So may prior notice and hearing, no? Before the bank could be placed under rehabilitation, may prior notice and hearing kang dadaanan, although it's summary in nature. But dito po, kahit walang petition to that effect, pwedeng ma-effect yung closure even prior to notice and hearing. Okay? So one of the consequences, because of the reasons earlier mentioned, dire consequences will follow if prior hearing is required. Bank runs will be the order of the day. You know more or less how people react, how depositors react. Marinig lang nila that the bank is going will be declared bankrupt, mga ganyang chika, di ba? So, nagkakagulo. Ang problema po dito, magpipilahan yan sa bangko, kawawa yung mga maiiwan na depositors. Did you get it? Okay? So, upon receivership, okay, the properties of the bank shall be deemed under custodia legis in the hands of the receiver. And from the moment the institution or the bank was placed under receivership, these properties shall enjoy exemption from garnishment, levy, attachment, or any execution process. In the meanwhile, creditors will stand on equal footing. And when I say creditor, that is broad enough to include depositors. In fact, they are creditors, no? No preference will be accorded to anyone. So it's really similar to corporate rehab effect of stay order when one has been issued by the rehabilitation court, no? Except that yung proseso nga na iba. You have to file a petition to that effect for putting a corporation under rehabilitation. Okay? But basically, parang nakakuha ka ng injunction, no? No execution, no preference will be accorded to any of the creditors, even if, in fact, preferred ang kanyang status. But of course, the rule is the preferred status is not effectively lost. But in the meanwhile, we are not going to recognize such preferred status because we have to respect the rehabilitation process. The idea here is to enable the receiver class to devote fully his time and resources to the rehabilitation process involving the bank. Okay? All right. Note, class, that basic rule is putting a bank under receivership does not dissolve it. Okay? Ang konsepto po ng receivership, nasa receivership pa lang tayo. Kung umabot yan sa liquidation, of course, that's dissolution time, baby. Okay? Pero kapag nasa receivership pa lang tayo, hindi po nadidissolve ang korporasyon dyan, ang bangko dyan. In fact, the concept is diametrically opposed to dissolution. Because receivership means, objective is, to make the bank financially viable again. So we want it rehabilitated. We want that corporation, the bank, to be able to overcome yung kanyang mga financial problems. You get it? So it's actually foreseeing. The receiver is there to help the organization become financially viable again. And so it has in mind continuation of corporate existence. And therefore, it is diametrically opposed to the concept of dissolution. The bank is not dissolved. The appointment of a receiver does not dissolve the bank, nor does it interfere with its corporate powers. Okay? The bank can still sue and be sued, but the case should be initiated and prosecuted through the receiver. Okay? In the meantime nga, since the assets and properties are held in custodia legis, held in trust by the receiver class, yung mga officers, mga directors, suspended ang authority nila with regard to the assets of the bank. And so in one case, class, Abacus Realty versus Manila Bank, a 2005 case. Sinabi po ng Supreme Court dito na yun daw, upon putting the bank under receivership, yun daw pong presidente ng bangko could no longer enter into a contract. Okay? So, yung presidente kasi, pumasok siya sa isang kontrata, nasa receivership stage na yung bangko, no? Pumasok po siya sa isang kontrata na kung saan binibigyan niya ng exclusive option yung kabilang party. Exclusive option to buy certain assets of the bank. Okay? The Supreme Court nullified the same for lack of authority of the officer concerned to do so. Why? Because at that point in time, the bank officer's authority to act upon properties and assets of the bank is deemed suspended. So it's now through the receiver. Did you get it? Okay? The BSP may further forbid. Okay, excuse me. Babagalan ko na. Okay po ba kayo dyan? Okay kayo dyan? May second floor na tayo. Baka umabot hanggang dito yung second floor, ha? Hanggang dyan, ma-extend yan. Ako, maganda yan. Okay. The BSP daw po can also forbid the bank from doing business. However, class, yung doing business na yan, ininterpret na po yan ng Supreme Court in its decision in Larobis versus Philippine Veterans Bank in October of 2004. Larobis Jr. versus Philippine Veterans Bank. Meron pang Philippine Veterans Bank, di ba? Okay? Decided in October of 2004. The court explained that while it's true that the bank is forbidden from doing business, such prohibition does not extend to foreclosure of mortgages constituted by borrowers in favor of the bank. Nakuha nyo? Ang nagpo-foreclose dito, si bangko. Yung bank under receivership, no? It's not the other way around. It's not a creditor of the bank foreclosing properties of the bank, no? It's the other way around. It's the bank foreclosing mortgages constituted by debtors in its favor. So that will mean magpapasok yan ng pera, no? So inexplain po ng korte sa Larobis Jr. versus Philippine Veterans Bank that the activity, okay, could enhance receivership process because it would mean, okay, the bank being able to enforce collection of claims. Okay, but if it would be the other way around, no, a creditor of the bank foreclosing assets of the bank, then the same would be forbidden following the legal consequences of receivership. Okay? Moreover, class, it is already a settled rule that interests accruing during the period of receivership shall not be paid by the bank, okay? Because the closure has the effect of, okay, exempting the bank from paying interest on deposit. As so explained by the Supreme Court, Fidelity Savings Bank versus Senson, the bank should not be held liable for interest payment because it is a matter of common knowledge that what enables a bank to pay interest is through generation of funds. How? By lending money as well as engaging in transactions, local or international, considering that the bank has doesn't have the right to do business then, no? It may not have enough resources to attend to the payment of interests earned by deposits. So interest accruing during the period of receivership shall not be paid by the subject bank. As mentioned, class, a while ago, while prior notice hearing not required, process is review thereafter is available. What kind of review? Judicial review. You can find it in Section 30 of the new Central Bank Act. A petition for certiorari may be filed within 10 days from receipt of the order, receipt by the directors, officers of the bank of the order coming from the BSP putting the subject corporation under receivership or liquidation. Petition for certiorari is the possible remedy. The petition cannot be filed by the receiver or the conservator that was appointed, but only class by stockholders of record. Any stockholder of record? Any stockholder of record? No. The requirement is the stockholders of record questioning the propriety of the receivership should represent majority of the capital stock of the bank. You get it? Okay. Now, just to let you know of the basic distinctions between receivership, bank closure versus dissolution of an ordinary corporation, no? I'd like to invite your attention to the court's explanation or decision in the case of INRE, petition for assistance in the liquidation of Rural Bank of Bocod in Benguet, no, Incorporated, et al. Versus Bureau of Internal Revenue, decided by the court on December 18, 2006. Okay? Under the Corporation Code, no, the SEC may dissolve a corporation. You know that under the Corporation Code, dissolution of a private corporation can happen involuntarily, no? And you know that despite the passage of the SRC, no, SEC retained its regulatory authority over private corporation, and in the exercise of administration, regulation of private corporation, SEC's authority to disenfranchise a private corporation remains intact, no? But administrative in character, okay? So under the Corporation Code po, the SEC can actually dissolve a corporation, but upon the filing of a verified complaint and after proper notice and hearing, okay, on grounds allowed by law. Okay. Now, basic requirement is, upon receipt by the corporation of the order of suspension by the SEC class, the company is required to notify and submit a copy of the order together with its final tax return to the BIR. Okay. The SEC is also required to furnish the BIR a copy of the order of its suspension. For its part, the BIR naman po is supposed to issue tax clearance to the corporation pag nabayaran na niya yung kanyang mga remaining tax obligations. And so, ang SEC po will only issue final order of dissolution after the corporation has submitted its tax clearance. Okay? You get it. Now, of course, you know that under the corporation code, that company which has been dissolved will be allowed 3 years within which to wind up its affairs. Okay? The 3-year period is non-extendable for the simple reason that it's statutory. However, for purposes, if the corporation really needs longer period to wind up its remaining affairs, no? Kasi upon the expiration of the 3-year period, the corporation loses corporate existence for all legal intents and purposes. At least during the 3-year period kasi, that company still enjoys residual corporate existence just so that it would be able to wind up whatever remaining affairs it has. Okay? So that during the 3-year winding up period class, the company can actually, what the corporation can do is to convey the assets and properties to a trustee, who then could continue winding up the affairs of the corporation even beyond the 3-year period. In contrast, the Monetary Board, insofar as banks, at ito po yung prevailing na rule pagdating sa bangko. So we are here carving out, diba, si bangko from the provisions of the Corporation Code insofar as involuntary dissolution of corporations is concerned. In contrast, the Monetary Board can summarily, no, and without need of prior hearing, forbid the bank from doing business, and then and there appoint the PDIC as receiver. The PDIC shall immediately gather and take charge of all the assets and liabilities of the bank and administer these properties for the equal benefit of those who have stake in the bank. Okay? The summary nature of the procedure for involuntary closure is specially emphasized in Section 30 of the new Central Bank Act. So if I may again invite your attention to Section 30 of the new Central Bank Act, which explicitly states that the action of the Monetary Board under the said section is final and executory and may not be restrained, no, by the court except via petition for certiorari filed by the stockholders of record representing majority of the capital stock. The PDIC as appointed receiver shall file ex parte with the proper RTC, again, without the necessity of prior notice or hearing or any other action if it will come to this point, no, petition for liquidation of the bank. The bank is not given, take note, ha, kasi sa corporation code, who can actually liquidate the affairs of yung winding up sa 122, who will undertake that? Pwede pong korporasyon na yan mismo, acting through its board, yung huling board, di ba? Pwedeng sila yung i-appoint na trustee. O pwede rin namang third party na trustee, but it's upon the instruction still of the incumbent board during that. Kasi sinasabi ko nga sa inyo, class, under Section 122 of the Corporation Code, no, pinagbibigyan pa rin po siya ng batas ng tinatawag na residual corporate existence. Because you have to realize, no, dissolved na yan di ba? But sinasabi ng law, you wind up your affairs, no, within 3 years. But you know for a fact that winding up would still require capacity on the part of the corporation. So pinagbibigyan siya ng 3 taon na meron pa siyang malinggit na lang na buhay, di ba? Malinggit na buhay in the sense that that existence should be utilized only for a specific purpose, and that is to enable it to wind up its affairs. Kasi sa pagwa-wind up, inevitable, nagbebenta ka ng assets, di ba? Nagdi-dispose ka in bulk ng mga properties mo, di ba? Para maging liquid yan, so that the settlement of claims of creditors and, of course, payment of liquidating dividends to your shareholders would be easier. Kasi ang hirap naman, nagbabayad ka sa mga creditors mo, ang binabayad mo, microphone, mineral water na may ano pa, na bawasan na, eraser, o sa'yo, ang i-assign ko sa'yo, ito, whiteboard marker, no? Sa'yo, Bacchus, di ba? Lamesa ang sa'yo, ha? Ang hirap nun. So the way to do it is dispose. A disposition is a juridical act, no? Kung dissolved na yan, defunct na yan, strictly speaking, wala na yan dapat capacity to act, no? Kaya po pinagbibigyan siya ng batas 3 years to enjoy still so-called residual corporate existence. Pero ang kaibahan daw po, kapag bangko ang korporasyon, ha? It cannot initiate or undertake its own liquidation. The basic rule is there should be a petition for assistance in the liquidation of the bank, and which petition shall be initiated by the PDIC. If the result of receivership is wala nang pag-asa to, hindi na to magiging financially viable again, aabot ka sa liquidation. And the way to handle it is, of course, you go through that process. You file a petition to that effect, where RTC, okay? Sobrang bilis ko. Pigilan mo ako kasi, ha? Pag mabilis ako, medyo magdala ka nga ng pito para ano, kasi napapabilis ako eh. Hindi ko na papansin ang mga oras, ha? Ikaw ang controller. Hello? Ayaw mo naman akong pansinin. Okay. So, nasa na ako? So, yun ha. Yun po ang napaka-importanteng mensahe ng Supreme Court dito sa INRE, Petition for Assistance in the Liquidation of Rural Bank of Bocod. May isa pa po akong gustong i-share sa inyo na desisyon still with regard to liquidation or dissolution of a bank. Rural Bank of San Miguel versus Monetary Board, 16 of February 2007. 16 February 2007. Ang issue po dito, still Section 30. That's why at least yung caudal pakitingnan lang po, ha? New Central Bank Act, Section 30. The Section 30 of Republic Act 7653 require a current and complete examination of the bank before it can be closed and placed under receivership. Kasi ang basis nga ng receivership yung findings ng Monetary Board, di ba? So anong klaseng findings yan? Saan ang galing daw dapat yan? Di ba? Maraming findings. Pwedeng yung findings na yan because it's an offshoot of examination, di ba? Pwedeng may report, pwedeng may, nagchika, di ba? To that effect. So ang requirement po ba is full, complete examination of the bank. The Supreme Court ruled that it's no longer strictly required. Okay? Hindi naman natin sinasabing bawal na may examination, but it's no longer strictly required under Section 30. Because it used to be a requirement, examination of the bank. However, class, with the changes made on Section 30, New Central Bank Act in particular, class, it would seem that a mere report of the head of the assigned supervising or examining department is sufficient. It is an established rule, sabi ng Supreme Court, in statutory construction, when the words of the statute are clear, plain, and free from ambiguity, it must be given its literal meaning and applied without any attempted interpretation. There is no doubt, there is no room for doubt, therefore there is no room for interpretation. Diba? You apply it as it is. You apply it in accordance with its plain meaning. Okay? The word report has a definite and unambiguous meaning which is clearly different from examination. A report, as a noun, may be defined as something that gives information or a usually detailed account or statement. On the other hand, examination means a search, investigation, or scrutiny. the absence of an examination before the closure of the bank, subject matter of this case, did not mean, however, so that there was no basis for such closure. Needless to say, the decision of the Monetary Board, like any administrative body, must have something to support itself. And its findings of fact must be supported by substantial evidence. However, it is very clear under Section 30 of the new Central Bank Act that such basis need not arise from thorough examination as required under the old statute. The purpose of the law is to make the closure of a bank summary and expeditious. Again, it goes into the reason why we could dispense with thorough examination. The purpose of the law in the closure of a bank, okay? The purpose of the law is to make the closure of the bank summary and expeditious in order to protect public interest. This is the reason why. This is also the reason why prior notice and hearing are no longer required before the bank, okay, can actually be closed. Did you get it? Okay. Now, the last item that I'd like to discuss with you, hindi pa pala, second to the last item that I'd like to discuss with you is ownership. Okay, ownership. Certain restrictions with regard to ownership. Yun pong mga BSP, no? Composition of the BSP, composition of the Monetary Board, di ba? So I'll just hold you responsible for those sections, no? Just remember yung fit and proper rule, no? Tsaka yung requirement that sa board membership ng bangko, mandatory yung independent director, no? I must tell you, class, yung origin, actually, banks ang nagsimula, BSP yung nagsimula nung requirement that corporations, private corporations, specifically public corporations, as defined under the SRC, should have at least 2 independent directors or at the very least 20% of the board, whichever is lesser, yun ang minimum, no? Basically, the reason is, bakit kailangan ng independent director? It's because of the necessity to ensure that in making decisions for the board, for the bank, objectivity is ensured, no? Check and balance is in place. May outside experience, and the directors who are independent can decide without being subservient to the interests of the major stockholders. You get that? And that's for the benefit of all. Okay? So, yan pong requirement na actually nag-originate sa BSP. 2 independent directors under Section 15 of the General Banking Law that should form part of the directors of a certain bank. Okay? 2 independent directors. Who is an independent director class? A person who is not an officer or an employee of the bank, its subsidiaries, affiliates, or related interests. Okay? Now, take note also of the fit and proper principle, no? As a rule kasi sa Corporation Code, removal, replacement of director is an intracorporate matter. By the same token, removal or replacement of an officer is a director's issue, di ba? While removal of directors is a stockholders issue. Kasi it's the stockholders of the authority to what? To displace directors. Following the procedure laid down in Section 28 of the Corporation Code, you have to muster the required 2/3 vote, di ba? It's essentially an intercorporate matter, no? But here, we have again a different rule. Kasi si Monetary Board pwedeng makialam in respect of the qualifications, disqualifications of the people running the affairs of the bank. Directors, officers their qualifications may be reviewed by the Monetary Board, and the Monetary Board can go to the extent of disqualifying those who are found unfit, no? So it's actually a deviation from what we have learned in corporation law. Okay? Mga deviations na ganyan. Why? It's all because we have this business to protect in the greater interest of what? The public. Depositors, creditors, and other stakeholders. Okay? Now, please take note that under Section 11 of the General Banking Law class, I mentioned to you yesterday, di ba? that generally speaking, except for rural banks, no, ownership of a bank will allow equity coming from foreigners, no? Bank ownership, may pwede pong sumali dyan na foreign equity. Pag sinabi kong foreign equity, citizens, okay, coming from a different country, no? Investors of coming from a different state, no? But the totality of equity participation of foreign investors would only be, generally speaking, up to 40%. Up to 40% of the voting stocks of the bank. Okay? All right. So that if X bank has 1 million voting shares, no? The most that foreigners could get or subscribe to the aforesaid 1 million shares would be up to 40%. Or roughly, well, of course, syempre, yan nga ang example kasi madaling mag-compute, di ba? Kaya nga nandito tayo sa profession na to, di ba? What is 40% of 1 million? That will give us, how much? 400,000 pesos. No, 400,000 voting shares. Gutom na di ba? Kaya, okay. Hindi pa, matagal pa. Okay. And so, Filipinos, no, 600,000 shares. Okay? Well, minimum yon sa Filipinos, no? Pwedeng, in fact, ideally, sana 100% Filipino-owned yan. You get the picture. But we're not disclaiming or we're not, we're not saying that foreigners can actually subscribe to shares of a bank, but only up to 40% thereof, of the voting stocks it has. Okay? Now, note, however, class, that with regard to companies which are subscribers also to the voting stocks of a bank, no? Kasi korporasyon, di ba? Ang natutunan nyo sa corporation code, no? Ang issue kasi dyan yung citizenship ng korporasyon who is a holder of the shares of a bank, no? So, critical issue there is, for citizenship purposes, how do we deal or how do we treat the juridical entity concerned, no? Ang rule po, insofar as banks are concerned, is the citizenship. It's found in Section 11, no? The citizenship of a corporation which is a stockholder of a bank shall follow the citizenship of controlling stockholders. Okay? You get my point. Whatever is the citizenship of your controlling stockholders will be the citizenship of the corporation, irrespective of the place where that corporation is incorporated. Did you get it? So that if I may cite an example, class, no? If the total voting shares of X bank is 1 million shares, okay, 400,000 Filipinos, another 400 foreign, and 200 Y corporation. So this is the issue. Okay? Y corporation holds the remaining 200,000 shares. You get it? You get it? Okay. Whether X bank is compliant with the citizenship requirement of Section 11 would much depend upon the citizenship of Y corporation. Okay? So how do we deal with this issue? How do we determine the citizenship of Y corporation? Depende po yan kung ano yung citizenship ng kanyang controlling na stockholders. You get it? Okay? We do not apply here incorporation test, no? It's irrespective of the place where Y corporation was actually created. You get it? Pwedeng foreign company yan, pwede ring domestic corporation, but for bank purposes, no, for ownership, for bank ownership purposes class, whatever is the citizenship of the controlling stockholders of Y Corporation shall be the citizenship of Y Corporation. And so, the citizenship of the remaining 200,000 voting shares. Get it? Okay? What do you mean by controlling shareholders? The threshold is more than 50%. As usual, as always, di ba? Controlling eh. We're talking here of control. You're in control if you hold majority at the very least, no? But the law is very explicit. It's controlling if more than 50% of the voting stocks. You get it? Okay. So if we look into the citizenship class of Y Corporation, at lumalabas na naman sa pag-scrutinize ng SOCO, na more than 50% ni Y, mga Pinoy. You follow? Hindi po yung presidente, no? Mga Pilipino, di ba? More than 50%, sa Pilipinas, sa mga Pilipino, di ba? It follows that the citizenship of Y, regardless of where it was created, regardless of where Y came from, di ba? The citizenship of Y for purposes of Section 11 is Filipino. Ergo, the citizenship of the remaining 200,000 shares will be Filipino. You get it? Conversely, no? Wow, may hagdan pala, di ba? Siyempre naman, paano sila makakaakyat doon kung walang hagdan? Kasi parang kanina ko pa iniisip, paano sila nakaakyat doon? May baging, no? Yung pala may hagdan. Ngayon ko lang napansin, parang hinaharap ko siya kanina, saan ba sila dumating? Yung pala, ha? Mamaya, ma-practice nga magpunta dyan, di ba? Okay. Parang mas maganda nandun ako tapos doon kayo nakaharap, di ba? Mas mataas doon Kaya lang, hindi pwede ikaw doon. Kasi yung ulo mo, tatama sa ceiling, di ba? Kaya tama ka lang dyan, di ba? Okay. So, pagbalik ta rin po natin ang sitwasyon, kung itong what's this? Ang controlling shareholders ni Y Corporation are foreigners, no? Pag sinabi kong foreigners, halo-halo na yan, ha? Kung ano-ano na yan. May Chinese, may Japanese, may sushiya, may ano pa yun? Sashimi, di ba? May tempura, may Korean, di ba? And so on and so forth, di ba? Halo-halo na po yun. Collective term lang yung foreign equity sa lahat ng foreigners, no? So that if the controlling citizenship of Y Corporation foreign, it follows that Y is foreigner, is a foreign company for purposes of Section 11. Ergo, the remaining 200,000 voting stocks will be foreign. And so, with this scenario in place, X-Bank would not be able to satisfy the continuing legal requirement of Section 11 that the equity participation of foreigners should only be up to 40%. You get it? Okay. Ngayon, class, pakitingnan lang po yung 40% na limitation na binabanggit-banggit ko, mag-a-apply din po kung yung stockholder Filipino, or corporation which is not a banking entity, corporation. Okay. Kaso mabibitin tayo. O gusto nyong ituloy bukas na? O sige. Sandali lang, anuhin ko lang may isa, baka makalimutan ko Merong nagtatanong dito ng freeze order, inquiry, etc. Whoever is asking for this, you could please take a look at section. It's in the Anti-Money Laundering Act. I just cannot remember if it's section 9 or 10, no? Yung application to freeze the asset subject matter of money laundering, if I can remember it right, no, it's done through the Anti-Money Laundering Council still before ang may authority to freeze the account is the Money Laundering Council itself, but with the changes brought about by Republic Act 9160 ba? 9160? 94, sorry. Okay, thank you. 9194, no? My understanding is that the authority to freeze the account now rests upon the Court of Appeals, but apply through the Anti-Money Laundering Council. Okay? The period is 20 days. Before, I think it's 15 lang. So 20 days yung duration of the freezing of account, but and of course the Court of Appeals has the discretion to extend the period. Now, ang problema po kasi with the changes brought about by 9194 is that natanggal na, before may remedy siya na parang pwede niyang ipalift, no? But within 72 hours, that was removed already by 9194. But I believe, well, this is just my personal opinion on this, no? That the way to do it, because he's also asking what is the possible remedy on the part of the depositor concerned, no? I believe that the general remedy of lifting that order would still be in place. Specifically in cases where grave abuse of discretion is clearly present on the part of the Court of Appeals in allowing the freezing of the subject account. Okay? So if I may just refer him to 9194 for the applicable provisions on his question. Okay, so I'll see you tomorrow. Tomorrow, class, we will discuss the remaining topics under banking. Yun na lang po, ownership of bank. As I said, I will just hold you responsible for the provisions regarding BSP, no? So kasi these are all self-explanatory. So we still have time for the other special commercial laws. In particular, listen, Act 3135, which is about extrajudicial foreclosure of real estate mortgage, and chattel mortgage law. So I'll discuss with you some of the cases, leading cases on chattel mortgage. And of course, our final discussion will be about intellectual property. Ihuhuli ko siya kasi meron akong konting presentation para hindi maabala. If that's all right with you. Ano pa yung kulang na special laws? Na-discuss na lahat. Corporate rehab, done, right? Done. Correct. Intra-corporate controversy. Ha? Anong ulit? Hello, isang araw na lang ako, ha? Tingnan natin, ha? So if we still have time, we'll just make a run-through of the important issues, no? New cases if you want, if that's your call, no? But basically, rehab kasi is an interesting topic, and there are many decisions already rendered by the Supreme Court following the rules governing corporate rehabilitation. All right, I'll see you tomorrow at 8:30. 8:30? 8 o'clock. 8:30.